All right, we're now moving on to handout 15, which begins our detailed discussion of trust. A trust is a legal entity that is created to hold the title to property for the benefit of named individuals. A trust is a private entity. It requires documentation and certain steps to create it and to bring it into effect. But once it is set up, it is an entity separate from the people who created it, separate from the trustee or the beneficiaries who control it and would benefit from it. In some ways, it is similar to a corporation because it is this idea that we're creating an artificial entity. But unlike a corporation, trusts are entirely private matters. To be a corporation, you must file documents, or to create a corporation, you must file documentation with the state. You must maintain certain filings. Certain aspects of corporations are public record. Trusts are entirely private matters, only involving the people that create them, manage them, and are benefiting from them, and very often do not require probate court involvement or other court involvement. To create a trust, you must first of all have a documentation set up or documents set up, and these would be created at the bequest of somebody called the settlor. The settlor is a person who wants to set up the trust and place certain of their property into the trust. A settlor can be one person or it can be multiple persons setting up the trust. The settlor, once the trust is set up, places property in the trust by giving title of the property to the named trustee. The purpose of the trustee is to hold legal title of the property and to use it for the benefit of whomever the settlors have named as their beneficiaries. A trustee is a fiduciary under the law. A fiduciary is someone who handles the property of another and is held to a great degree of scrutiny and trust, and it is basically the job of the trustee to handle this property solely for the profit and benefit of the beneficiaries, and that the trustee, other than getting a reasonable compensation for their job, has no right or no ability to utilize or profit from the property that's in the trust. The beneficiaries, of course, are the parties named to be the beneficiaries under the trust, and they are the persons that the settlors determine want to be protected and have the property made available for their use and for their benefit. There are single trusts created by one settlor. There are joint trusts created by two or more settlors. There are testamentary trusts, which are created as part of a last will and testament. There are living trusts, and as you might detect from the name, a living trust is created while a person is alive and well during their lifetime. They set up a trust and they place property in it. A revocable trust is one that can be amended or revoked or abolished. Property can be placed in it or can be removed from it at any time. An irrevocable trust is one which, in effect, creates a gift. Once a settlor sets up an irrevocable trust, by its terms and by its definition, it cannot be undone, and any property that's placed into it, it's as if the settlor was a donor making a gift to a donee, and just as when a gift is finalized, the title to the property has changed, and the donor has no right to take it back. It's the same thing in a trust. Once the property has been given to the trustee, the settlor has no right to take it back, retains only whatever control the trust gives them, which very often is quite limited. In our practice, there are usually three types of trusts that we encounter. First type is the testamentary trust, and these are utilized mostly by people who have children or relatives who either are very young or who they do not feel can handle money properly, were not able to take care of themselves, and would squander or lose any assets that might be handed to them under the wills of the settlors. So in this type of situation, nothing happens while the settlors are alive, but upon their death, their will is probated, their estate is settled, and once the estate is resolved, then whatever assets are left are handed to the trustee, and the trustee holds them for the benefit of the named beneficiaries according to the terms and purposes that have been set out by the decedent, by the testator. Again, this is very popular, particularly for parents with young children, to be able to name somebody that if something happens to both of them, this person will be responsible for handling the financial matters of their children and for taking whatever assets were left by the parents and making sure that they're there for the children's benefit. The next type of trust that we utilize most commonly is a joint revocable living trust. Although it can be a single revocable living trust. And what these trusts accomplish is that while the settlers are alive, they set up a trust, they set up this entity, they place property in it, and one of the basic things that this trust does is that it provides that upon the settlor's death or deaths, the property does not have to pass through the probate process. Instead, it is handled entirely privately by the successor trustee, who makes sure that the assets get to wherever they're supposed to be for the benefit of the named beneficiaries. One of the particular benefits of this type of trust is under legislation that's been in place for about 50 years in both Rhode Island and Massachusetts. The settlors of a revocable living trust can be their own trustees and can be their own beneficiaries. And then what they would do is they would name a successor trustee to take over whenever the one of them or both of them had passed away or became incompetent and couldn't handle the property. And for tax purposes, these types of trusts are also handled under the settlor's tax ID number. They're considered part of their assets. So it is tremendously beneficial because these folks have now set up a way to avoid the probate process, to provide for the circumstances where they have both passed away or they have become incompetent. They have a successor trustee already named, ready to step in and take over for them. And yet, while they are still alive and competent, it allows them to retain full control and to be able to do whatever they want with the property. And again, because of the revocable nature of the trust, they can amend it, they can change it, they can abolish it, they can put property in, they can take property out. These are very flexible instruments, and more middle-class people are beginning to utilize them as a basic reality in their estate planning. Very often, either a testamentary trust or the revocable living trust also can deal with what we call marital deductions. There are estate taxes in Rhode Island that come into play at a little bit over $1.5 million. Federal estate taxes are now, under Mr. Trump, over $10 million, so they're usually not an issue for most of our clients, but Rhode Island estate taxes can be. And one of the things that we can do with trusts is for a married couple, we can set up a situation where the trusts are arranged in a way that they get full benefit of each of their $1.5 million exemption under state law, which means that their joint estate can be sheltered up to $3 million from estate taxes. This is particularly popular with people who have children and grandchildren and want to see them get as much of their assets as possible and to keep the state from getting their cut upon their death. And again, a marital deduction trust can be set up either in the last will and testament, or it can be set up as part of a revocable living trust. Some other types of trusts that are less common and that we don't tend to use. Let me go back for a second. We use irrevocable trusts in our practice for Medicaid purposes. Under present regulations, everyone who becomes 65 is able to apply for Medicare to have the government to pick up part of their health insurance and part of their medical bills if they become ill. There is another program called Medicaid, the purpose of which is to provide care for parties who are indigent. And the two basic rules of Medicaid are you can only have $4,000 in assets to your name, and you cannot have made any great gift of assets, a large gift of assets, in the last 5 years. Many middle-class people reach a point where they have assets that they don't believe they're going to spend or need during their lifetime. They want to see them pass to their children, and they are quite terrified of ending up in a nursing home, which in Rhode Island and Massachusetts average approximately $12,000 a month at present in costs, and which would have to be paid by the person who is ill or by their family if they do not qualify for Medicaid. If they qualify for Medicaid, then the state with federal money will pick up the cost of the nursing home expenses above whatever income, Social Security or pension, the ill person has coming into their name. We very often are called upon now to help people plan for their futures, and we have been using irrevocable trusts under present law in Rhode Island. If a party puts property into an irrevocable trust, remains out of the nursing home for 5 years, that was a gift, they've gotten past the 5-year look-back period, that property will not be touched or will not be sought after by the state for reimbursement for nursing home fees. And at present, it does not, having made that gift, once they've got past the 5 years, does not disqualify them from applying for Medicaid at a point when they need to go in the nursing home. So they're not all that common that we do that, but we do use that as a means to help people determine Medicaid eligibility and help people when a relative or a spouse has to go into a nursing to apply for whatever benefits they're entitled to, and to make sure that they get the benefits of whatever exemptions and deductions they are allowed. There are special needs trusts. Many disabled people are on Social Security disability income or other types of programs like Medicaid, which severely limit the amount of income or the amount of assets they can hold. Very often these government programs provide services and medical care that families could not pay for at any price, no matter how much money the families had. So one of the things that Congress has allowed, they have passed legislation that created this and allows it, is that someone who has a relative, a friend, a child who has special needs, who is disabled and is on various governmental programs, if the person wants to give money to benefit that person, they can set up what's called a special needs trust. The basic idea of this trust is the disabled person does not have control of it. It must be held by a third-party trustee, and it can be used for items that would not normally be covered by the other governmental programs. And so long as the disabled person does not have direct control or it's not getting an income stream from it, it can be set up in such a way that it does not prevent them from receiving their benefits from the government. It does not disrupt them. So this is very, very popular particularly with parents who have a disabled child. It allows them to leave certain assets for the care of the child and to give them a means of life that might be higher than what they would be able to obtain just by being on governmental benefits, but at the same time does not cause them to lose their governmental benefits because this money is out there. In Massachusetts, for many, many years, having a corporation to hold property real estate was a very cumbersome and difficult reality, and over time something developed called a nominee trust. In a nominee trust, the names of the beneficiaries can be kept secret permanently, so that you can buy a piece of real estate. It can be placed in the name of the trustee who runs the nominee trust. All aspects of the real estate, including later on financing it or selling it, are controlled by the trustee alone, and the beneficiaries' identities never have to be revealed. This is not allowed in Rhode Island. In Rhode Island, if you are going to refinance or sell a piece of real estate that is in a trust, the names and identities, addresses of the beneficiaries have to be revealed, and they are part of the process for selling the property. Courts sometimes impose a resulting trust, where somebody has obtained property on a promise that they would take care of it for another, and then they fail to do that. They fail to act on behalf of the other. The person who gave them the property, or in more likelihood that person is gone, the person who was supposed to benefit from the property, can sue in Superior Court, and if they can prove that the person accepted the property in trust, even if this was verbally and there was no writing, but the intention of the person handing over the property was that the trustee was to have legal title only and to hold the benefit for the third party who is now suing, the court will create a trust by judicial order. This is called a resulting trust, and the purpose of this trust is to honor the intention of the person who had originally given the property and to prevent unjust enrichment on the behalf of the now called trustee, the recipient of the property. There are also trusts called blind trusts. These have become an issue recently as several Republican representatives and even a couple of Democratic representatives and senators were called to task because they had made large or their trusts had made large sales of stocks just before the market fell in reaction to the coronavirus 19 realities that are going on. And several of these representatives, senators are very quick to come out and say that we have no control over that at this point in time. It is public knowledge because it must be reported under the federal reporting requirements at this time, but that when we began to run, or when we were elected to the Senate or the House, we placed our property into a blind trust. We handed everything over to our financial advisors. They are the trustees, and we obtain income from the trust, but we no longer have any say or control, nor do we even have the right to know what they are doing with the assets. So you will see these from time to time. They are utilized by politicians and other folks who would have a conflict of interest, possibly, if they were wheeling and dealing in the stock market or the bond market, and also holding some type of public trust or public position. At the bottom of the page, there's a little graph just showing what happens with the property when a trust is created. The settlor is the person who creates the trust, and they hold legal and equitable title to the property before it is placed in the trust. Once they create the trust and they place the property in the trustee now controls the legal title of the property, while the beneficiary has the equitable title, or the equitable rights to the property. By holding legal title, that means the trustee, for all intents and purposes, controls, manages, is responsible for the property. It's one who will be sued if there's some issue with the property. They have the power to deal with the property and to face the outside world in any relations concerning the property. The beneficiary basically usually has very little control other than to accept whatever benefits the trustee is required to give to them under the provisions of the trust. At some point in time, unless it is a charitable trust, all trusts will end, and ultimately there will be ultimate beneficiaries who at that point in time would receive, again, both legal and equitable title to whatever property has been in the trust. We did not talk about charitable trust, but another trust that you can create is something that will take a gift from you, place it in a trust to be used for specific charitable, educational, social, religious purposes. There are slightly different rules for these trusts tax-wise, and there are also different rules in terms of these trusts can pretty much continue forever so long as they are for a charitable purpose. All right, going on to page 2 of handout 15. Just some quick things about the benefits for setting up different trusts. And as I said before, the traditional reason for establishing most trusts is that because the people who hold the property wanted to benefit somebody who they are afraid is either too young, too incapable, too crazy to handle the property correctly on their own, and would quickly become lost and destitute and would have not made good use of the property. So by utilizing a trust vehicle, they can guarantee that somebody who they believe has the financial wherewithal to handle the property well and correctly will be in charge, while the beneficiaries will still be benefiting. Right? The other reality is that the property which is in the trust avoids the probate process. Now, this is important for several reasons, which we'll get into when we talk about probate court proceedings. But the reality is probate exists, as I said in the last handout, for the benefit of creditors more than it does for the benefit of the heirs or the beneficiaries or the benefit of the decedent. Creditors have the right to file claims, they have the right to demand payment, and they have priority over the beneficiaries. So one of the realities is that many people attempt to leave as little property in their probate estate as they can. Now, another reality is that probate takes time and money to administer. In Rhode Island, it's a minimum of 6 or 7 months, probably closer to 8 months, that an estate has to be kept open because of the various notice requirements and rules. In Massachusetts, basically an estate has to be kept open for a year from the time it was set up, and it usually takes a few weeks at a minimum after a person dies to set up the estate in court. Again, these court proceedings are public. Anybody can pull up the court file and look at it and see what's in it. And they are expensive. There are court fees to pay. There are lawyers' fees that would have to be paid. There are executor administrator fees that might have to be paid. All of this can be avoided by having your property in a living trust before you pass away. The living trust provides that the property does not go through the probate process. It is not subject to the claims of creditors because it is not part of your estate when you die. So particularly even for young couples who may have a lot of bills but have certain insurance policies or certain assets, placing them in a trust gives them a way to pass those assets on to the spouse or to their children without creditors being able to come after them and make a claim for them after the death of the executor, after the death of the testator. We spoke about irrevocable trusts and how we use them for Medicaid purposes. There are also trusts that are established to save on income taxes or estate taxes, and we had also spoke a little bit about charitable trusts. As the middle class in the United States had been growing up until very recently and becoming more wealthy, and as the baby boomers, which were the largest group in the population, are getting older and beginning to pass away and to think about their estates, trusts have become more and more popular and have become more and more prevalent as a part of our practice. 30 years ago, only people who were extremely wealthy or extremely knowledgeable about financial matters would even venture into setting up a trust. Now, many types of folks, if they have any assets at all, are interested in having trusts to control their property and to provide a vehicle for the orderly transfer of the property upon either their becoming too ill to handle it or upon their deaths. All right, that is it for handout 15. We will conclude this and we will move on to handout 16 next.